Okay, good afternoon, everybody. Thank you for joining us as we wrap up our 2024 version of Estate Administration Week with this final Zoom presentation that promises to be to go out with a bang here with a fun little game and some interesting questions and some things that we've heard throughout the week, but also things that our presenting lawyers are familiar with in the conversations that they have with the folks that they work with. So thank you for being a part of another great week. If this is your first session or one of many, we appreciate that you've taken the time to join us and our lawyers throughout the week to learn about these valuable topics and get some information around effectively administering an estate if you are named an executor or personal representative. My name is Matt Mandrusiak, and I am the Manager of Philanthropy with the Edmonton Community Foundation. And it's my pleasure to host this wrap-up session. We're so happy that you could join us once again. Today's session is part of our annual Estate Administration Week, dedicated to providing Edmontonians with important information about the ins and outs of effectively administering an estate. If you are or expect to be a personal representative or executor for a loved one's estate, the Edmonton Community Foundation has offered 12 sessions over the past week, both in person and online, to provide you with a lot of important information about how to go about that role. Well, I guess we don't need details about registering for any more since this is the last one, but if you want to catch some of the recordings, we did do 4 online presentations. Those sessions will be up for your consumption in the next week or so, so you're more than welcome to go to ecfoundation.org, which is right over my ear here, to find that information about the recorded sessions. At Edmonton Community Foundation, our role is to help people create their legacy for our community. We are a trusted resource for Edmontonians to provide ongoing endowment support for the charitable organizations and causes they care about. As a result, we have many conversations with people in our community about their will and estate plans, and we know how important it is for people to learn valuable information from wills and estates professionals. Just before I introduce you to our presenters for the session today, I would like to let you know that at the end of this presentation, you will be given the opportunity to fill out a survey. Once you click exit, that pop-up box will come up on your screen. We do ask that you take a few minutes just to quickly fill out that evaluation. We really do value the feedback that we get from all of the sessions, and hoping that we are continuing to provide something that's worthwhile for everybody participating. So do please take a minute before you log off and get ready for the weekend to give us a little bit of feedback. There are some opportunities for Q&A today, although this game is a little bit different than what we've seen from the typical presentation. But if you would like to ask a question that's maybe not covered in the game that Mike and Allison will be playing today, please feel free to use the Q&A box. We will potentially be getting to some of those questions throughout the presentation. So please use that, utilize the Q&A. And without further ado, since no one's here to see me, I will gladly introduce both Allison and Mike. They have sort of been the two faces of closing out our Wills Week and our Estate Administration Week with something fun. They're back again for this year, and the sneak peek that I was given looks pretty impressive, so I think we're in for a pretty good show. So please welcome Allison Barkwell. Allison was admitted to the Alberta Bar in 2006 and is currently a partner with Barr LLP, excelling in estate planning, estate administration, adult guardianship, trustee, and estate disputes. Her services to clients include creating estate plans, preparing applications for probate or administration, and advising personal representatives, trustees, and beneficiaries in contentious and non-contentious matters. Allison collaborates closely with clients to carefully consider their personal situation and objectives, provides advice to clients on how to best organize their affairs, and crafts customized estate plans, ensuring the unique wishes of her clients are fulfilled. Allison is a dedicated volunteer in the community and currently serves on the boards of the Today Center and SEEN, the Edmonton chapter. When Allison is not in the office, you can find her on the golf course or running in the River Valley. She ran the Tokyo Marathon in March of 23, which was her 5th major. Allison is running the Jack and Jill Marathon in 2024 and hopes to run the Boston Marathon in 2025. Very cool. That beats the Disney Marathon that I will be running in January. Please also welcome Mike Simons. Mike enjoys working with clients in all areas of estate law, including grants of probate to allow for proper administration of an estate. First-hand knowledge of the strains and stresses of this process help Mike foster communication amongst parties seeking to address and resolve issues before they grow into conflict. When conflict is unavoidable, Mike applies his knowledge of estate law to estate dispute and litigation matters. Mike is the past chair of the Wills, Estates, and Trust section of the Canadian Bar Association. Prior to law, Mike had a 6-year career in the wine and spirits industry, which is very cool. As a partner with McCuaig, Desrochers LLP, Mike serves as chair of the management committee and continues to assist clients with practical advice, drawing upon his broad base of experience. And thank you both for being here and taking the time to present today. I know you've got something pretty excited planned for the group, so I am going to hand it over to you. I will turn off my camera, turn off my mic, and maybe jump on here and there if I'm prompted, but let everybody else enjoy. So thanks, Mike and Allison, over to you.
Thanks, Matt. Really appreciate it. Allison, such a pleasure to be presenting with you again.
Yes, nice to see you again. I'm happy they let us keep the band together, but maybe that's why Matt's disappearing. He doesn't want to see what's about to transpire.
He drew the short straw having to host us today.
I think he did. It is Friday afternoon.
Yes. And this is the most prepared we have ever been, I think, which means that everything could go sideways. I hope that our technology works. I hope people will be patient. I hope we won't cause too many glitches, and hopefully we'll have some fun and at the same time be able to help people learn a little bit about estate administration issues.
Yes, and again, Mike, if everything goes off the rails with respect to our presentation, it's similar to some of our estate administration matters, and we just roll with it and we will deal with it as it comes, and hopefully we can educate the people who are attending. So thank you so much for spending your Friday afternoon with us. We hope we can give you some good information in a fun, informative format, and we get to play Jeopardy today.
You bet. And if it all works well, full credit to my student Hadil. And if it doesn't work well, then I'll take the blame. Yes. Matt also just put a note in the chat that if there's questions, to use the Q&A function on Zoom for anyone who has questions, and we'll try and deal with as many as we can as we go through the presentation today.
Yes,
Allison,
and Matt,
I think, well, go ahead.
Oh, sorry, and Matt, please feel free to interrupt us if you think it's a good time for a question, because sometimes Mike and I get a little carried away, and we are well aware of that. So we appreciate you being here to ensure that we answer questions, or when we get sidetracked, you get us back on track.
Happy to do that. I'll jump in when and if needed.
Perfect. Allison, as we usually do, should we start off just sort of with estate terminology 101?
That would be fantastic. Would you like me to start, or would you like to start?
I would love for you to start. What's a will?
A will. So a will is a document you prepare where you get to decide who gets to be the executor or the personal representative of your estate. So that's the person who is going to administer your estate. And then in your will, you get to decide where your estate is going upon your death. So you get to maybe give some specific gifts in the will. So if you wanted to give your lovely friend Allison Barkwell $5,000, you could put that in your will and she would receive it upon your death. Then you get to decide where the rest of your estate goes. So after all the bills and taxes are paid, then who is to receive the remainder of your estate? So you can give it to friends, you can give it to family members, you can give it to charities. There's lots of options out there. We do kind of have 3 general rules with respect to who you need to leave your estate to, and maybe Mike can speak to that.
You bet. And I should also say that lawyers have a bad habit of using different words to say the same thing. So personal representative, executor, trustee, if we use those terms, they're all one and the same for the purposes of today. They're the executor of the estate. Yes, in Alberta, we're lucky enough to have testamentary freedom subject to our obligations to our spouse or dependent children, or children who are 18 to 22 and in post-secondary education, or children who are above the age of 18 but are unable to earn a livelihood due to a physical or mental disability. So those are sort of you can do whatever you want with your estate except for these legal obligations. Is that a fair summary, Allison?
That is a fair summary. One thing I would just like to add, because I know Matt had sent us a note earlier after we had come up with our game, just with respect to when someone passes away and we make a court application to get a grant of probate, meaning there was a will, or a grant of administration, meaning there was not a will. It is a court application to the court which sets out all the assets and liabilities of the deceased at the time, who the beneficiaries are, where they live. And we discuss what the probate fee is. And I know we all have Google as our lawyer and sometimes our doctor. Dr. Google has given me lots of bad information over the years. But just so you know, in Alberta, the maximum probate fee payable to the government of Alberta is $525. Sometimes when you go onto Google, you might see different information about 1.4% or 1.5%, and those are different provinces in Canada.
That's right. The morbid joke that often gets made by state lawyers is Alberta is the best place in Canada to die. So in terms of state fees, probate fees, and then on top of that would be legal fees and other expenses. But in terms of government and court fees, it's very inexpensive to get probate. And with the new surrogate digital service, we just call it SDS, which is essentially a way lawyers can now apply for probate online in most circumstances. It has expedited and sped up the process tremendously. It's a fantastic advancement to our practice area.
Yes, so once the application has been submitted on the surrogate digital system, it may be less than 3 weeks before you actually have the grant from the court, and the grant is what the personal representative or executor uses to begin dealing with the assets of the estate.
So we've talked about a will, we talked about personal representative, executor, we talked about probate or grant of probate or grant of administration. Any other 101 you want to touch on? Do you want to touch on enduring powers of attorney in respect to how they relate to estates?
Oh, yes, because I've had lots of problems with those.
Yes.
So sometimes before someone passes away, they lose capacity. I'm sure some of our attendees may be aware of this. And if they have prepared a will, they usually have prepared an enduring power of attorney. And the enduring power of attorney is the document that allows a person to pay your bills and to deal with your property while you are still alive. It can come into effect immediately upon signing of it. It can also come into effect at a later date. So maybe upon loss of capacity, and a doctor has signed a declaration to say, this person no longer has capacity to make financial decisions. As such, the person appointed as the attorney, not being a lawyer, it's just whoever they pick, their friend or family member, can then begin paying their bills, dealing with their investments. If they need to sell their house, they can do so. How this relates to an estate is once the person dies, the power of attorney ends, and then the will comes into effect. So whoever was acting as the attorney then has to potentially account to either the executor of the estate or the beneficiaries of the estate. And we need to know this later because Mike and I have some interesting stories about maybe funds that have gone missing.
There's always interesting stories when we're talking about this stuff, Allison.
There are.
So I think that sort of gives the main glossary of terms well, let me just say a couple more things.
Okay.
Talked about executor, talked about wills. Maybe we should just remind everyone what intestate means.
Okay, so intestate means that someone has died without a will. And if they have died without a will, we have legislation that basically states where the estate goes when you die without a will. I believe, Matt, probably with the Edmonton Community Foundation, there was a handout that went out this week or somewhere that gave all the glossary of terms that we usually have.
Yeah, that's right. And that, I don't know if it's up on the website now, but we'll make sure that it is downloadable for people starting next week.
Okay, perfect. Thank you. So actually, I had an estate this year where someone died. They had never been married. They had no children.
Okay.
They had 9 aunts and uncles on one side and 4 on the other. So parents had predeceased. Some of the aunts and uncles had predeceased. So we ended up going down to first cousins.
Wow. Yeah.
So I had 16 beneficiaries who were first cousins, and basically my clients who were acting as the executors had to play Let's Build a Family Tree on Ancestry.com.
That sounds like a lot of fun. Yeah, no, not having a will can definitely cause some concerns. And I just wanted to make sure we let people know what that meant. And then, of course, the term beneficiary is someone who benefits under the will, whether they're a beneficiary of a specific gift that you talked about, Allison, where all my clients like to give you $5,000, or a beneficiary as part of the residue or residuary beneficiary. That's residue is whatever's left. So I always tell clients it's pieces of the pie. Who gets what size piece of the pie? That's whatever is left after any specific gifts are made.
And all the debts are paid, including money owing to CRA.
That never happens, does it?
Never. No. Never. Okay, are we ready to play some Jeopardy? Matt, you ready?
Let's hold our breaths.
Uh-oh.
See if this, and thank you for everyone's patience. Okay, let me see. Oh.
Uh-oh.
Just a moment. I need to share screen. There we go. Share screen.
Ooh, look at this. I'm impressed, Mike.
Well,
and I thought I called you a dinosaur earlier today. Wow.
Okay, here we go with the topic.
Mike, I will start with executor's errors.
Oh, just wait. We got to go through all the topics.
Oh, okay.
Wills, probate problems.
That never happened.
It's inherited and devastated. Estate intrigue. And beneficiary bad.
That never happens either, Mike.
Sorry, Allison, where did you want to start?
Can I please start with executor errors for 200?
You betcha. I will distribute the estate immediately after probate.
Oh, I have to put this in the question format, don't I?
You betcha.
What is personal exposure to estate claims?
Look at that, $200 to Allison. Fantastic.
Mike, are you going to see this after the show?
Yeah, no, you're gonna, there'll be small, unmarked, non-sequential bills in a bag left out inside your office later.
Perfect. Thank you. Okay.
So Allison, let's talk about personal exposure and distributions.
Yes, estates, unfortunately, Mike and I have to be the bearer of bad news. Estates, once you have been appointed after someone passes away, I'm guessing the average estate where there's no hiccups is probably about 1.5 to 2 years, Mike, would you say?
Yeah, you know what, I used to say an average estate is 2 years. With the new system, that's sped up to some degree, and Canada Revenue Agency has sped up to some degree. But I'm a long and luckily married man, and I always like to underpromise and overdeliver in all things. So I generally say 2 years.
Okay, so the average estate is 2 years, according to Mike. And he is correct. It really depends on, there's a whole bunch of factors that are completely outside of our control and outside of the client's control. With the estates, there's generally a bunch of bills to be paid when someone passes away, most specifically to Canada Revenue Agency, because unfortunately, we have this thing in Canada that it is deemed you have sold all of your property at fair market value the moment before you pass away. So that creates a taxable event, and that requires the estate to have to pay tax. So where does the money for the estate come from? It comes from the assets that the deceased owned at the time of death. So if Mike were to get a grant of probate and then distribute the entire estate to the beneficiaries, Mike is actually on the hook.
That's right. So I mean, what I always advise my clients, and I'm sure you do as well, is that they should get tax advice from an accountant who's qualified to work in dealing with estates, and determine if there's some exposure or liability for the estate for a tax burden. As lawyers, we generally aren't equipped to give tax advice, but we do have that inch deep, mile wide knowledge. And so, for example, a personal residence generally is capital gains exempt, so there's not going to be a big tax bill there. But if somebody bought a cabin out at Pigeon Lake 40 years ago for $10,000, and at the date of death, that lakefront property is worth $1 million, and it's not their principal residence, that's a huge tax event, right, Allison?
That is a huge tax event. So Mike, I currently have an estate where the deceased died 8 years ago. And get this, she had 3 properties at the time of her death. And the previous advisor on the file didn't advise the clients that they needed to file tax returns.
Oh, there's
So
going to be some late fees there.
some late fees, some penalties, disposition of 3 properties. One of the properties has gone up significantly in value since the date of death, so there's going to be some capital gains tax payable on it. It is a huge mess, and this is unfortunately due to a situation where the clients didn't receive the appropriate legal advice or accounting advice, and now they're having to dig out of this pickle, and unfortunately, we have some very upset beneficiaries.
And I mean, they should be upset just because how long it's taken to begin with, but that's the kind of catch-22. Executors get a lot of pressure from beneficiaries saying, well, the family member or the loved one died 6 months ago, why haven't I got my money yet? And so I find it very important to be very communicative with beneficiaries, for executors to be very clear up front saying, don't start spending this money. It's going to take a couple of years before we're able to distribute everything. Because of that CRA tax burden that has to be dealt with. And then once it's dealt with, typically an executor with their accountant will apply for what's called a clearance certificate, which is, I always say, CRA's last bite of the apple. to say, speak now or forever hold your peace on tax burden. And then the other thing that we haven't yet talked about is that 6-month waiting period for a potential claim for family maintenance and support. So we talked earlier about the obligations. You have testamentary freedom except for those obligations, a spouse, minor children, or adult children in school under 22. And the one that sometimes comes back to become an issue is adult children who are unable to earn a livelihood due to a mental or physical disability. And if you distribute before 6 months of the grant of probate, as an executor, you're wearing some personal liability for the amounts distributed. And if a claim comes forward, you can be personally liable and have to make that whole, and or go chasing after beneficiaries who you are now were in good favor for advancing quickly, but are now in trouble because you're asking for money back.
And usually the money's spent. When I was a very junior lawyer and just started doing this estate administration practice, I did have a beneficiary after I received the grant of probate, and I had advised we'd received the grant of probate, show up at my office asking for $35,000 because she had just bought a trailer. I was like, no, I can't give you the money. So from very early on, I learned to let the beneficiaries know it'll probably be a year from the time we apply before you actually see any money.
Yeah. And when you're making that application, I mean, the executor, part of the time constraint, and might address one of the questions asked, is that, I mean, the executor has to gather a tremendous amount of information in order to put that in the probate application about the deceased, about all of the assets, about all of the beneficiaries, and the original will and a death certificate. So there's a whole process of information gathering, which takes a considerable amount of time. And all that has to be put in place before you can apply. So while we sometimes are excited that we can get probate in 3 weeks, once in a while you get a client that takes 6 months to get you the information and then is frustrated when probate isn't granted 3 weeks later. But it takes time to get all that information, it takes time to input all that information, and it takes time to then get the grant of probate. I had one this week where the justice sent back a note online asking for a clarification. I think it was just a misunderstanding on a certain sentence in the application. We put it back in, and that time the justice must have been waiting for my comment because they issued the grant very quickly. But if that justice had ended up in a 3-month trial, it might have taken longer. So you just don't know.
So I do see a few questions in our questions. So what is required of an executor before an application for probate is made? So a question, they should actually advise the beneficiaries of the contents of the will. Sometimes it does take them time to gather the information. I know in my practice, sometimes I am the first notification to the beneficiaries that they are beneficiaries under the estate. The executor's job, especially at the beginning, can be all-consuming because they're having to notify a bunch of different organizations, financial institutions of the person's passing, deal with the funeral arrangements. But if they're contacted by one of the beneficiaries, then they should give them a copy of the will. Next question, Mike, you can answer this. What happens if it's more than a few years? They were supposed to sell a house and now someone's living in it.
Oh boy. You know, it really, there's no easy answer to that one. I guess the question is whether the executor is now motivated to do something. We often get files where executors just get overwhelmed and they pull an ostrich and stick their head in the sand, and then they can't get motivated. In that case, sometimes someone will hire Allison or me to offer nicely to say to the executor, you don't seem to be able to deal with this. Why don't you step aside and let someone else deal with it, or make a court application to replace an executor, or for something called advice and direction. the fact that someone's living in the house doesn't really impact the probate process. It
It
impacts,
doesn't bode well for disposing of the asset, though.
yeah, that's a whole, that's someone else's problem, Allison.
Yes, with the estate administration, we do have something called the executor's year. And the executor's year is supposed to be that you're supposed to try and have the estate wrapped up in a year. That doesn't actually happen in practice because, again, we're dealing with a bunch of different things outside of our control. First of all, trying to gather what the assets and debts were as of the date of death, making the application for the grant of probate, sometimes trying to locate beneficiaries.
Yes, I think we're gonna get to that at some point.
Okay, should we
Okay.
back
I
to
think
our
we better try, let's see if I can make this work again. Okay,
Mike, it's your turn.
oh boy, let's see.
Oh, you
I
missed the
think
question.
I think I screwed up already, eh?
Okay,
How
Oh,
did I
no.
end up-
you can go to the next one. You just missed the board, but that's okay.
Okay, let me,
Go forward.
let's see on the slide.
Okay.
Oh, there we go, I think.
Oh, good job. Okay, what are you going to take, Mike?
I think I'm gonna go executor's errors for let's go for executor errors for 400.
Okay, so answer. I decided to pay the deceased credit cards off before filing the tax returns.
I think what is personal representative's liability to CRA?
Ooh, this is a bad one. And I unfortunately see this way too many times. Probably you too, Mike.
Yeah, the ambitious executor.
Yes, they're trying to do the right thing.
And, you know, bills got to get paid, but there's one bill that has something called super priority. And that's
Yeah. But one of the great things about being an executor is it is the only time in your life that you will have priority over CRA for your expenses. So those are your out-of-pocket expenses for acting as the personal representative. But of course, Canada Revenue Agency needs to get paid. And if you pay other creditors off before paying CRA, CRA can come after you personally as the executor for the money owing.
Yep, it's so you know, there's a good gold cliche, death and taxes, and we're
Yeah.
dealing with both of them all at once here.
Yes. So I always advise my clients to not pay anything other than the ongoing mortgage payments and that, but don't pay off the credit cards until you have dealt with CRA, because no one wants to be personally liable to CRA because they have very deep pockets and they have the rest of your life to try and collect from you.
Isn't that the truth? Allison, it's your turn.
It's my turn. Okay, let's do executor errors for 600.
Okay, here it comes. Maybe. There we go. I paid myself 10% of the estate because I worked hard. Now the beneficiaries are mad at me.
Wonder why. What is executor compensation, Mike?
Look at that. You're a genius, I swear. Amazing.
Executor compensation. Do you want to talk about that and how that works?
Yeah, that is always a question that we deal with, and I think there's actually a question in the Q&A that we can answer at the same time. So executor compensation, there's a couple of different ways it works. Sometimes people will put it in their will. They'll say, my executor gets $5,000. That's what they get. Sometimes, and more often, they don't put anything in their will. And there's some method to that madness. One of the reasons it's not specified in a will sometimes is that when someone's making a will, they don't know if their estate is going to be simple or complex. Die with money in one bank account, pretty simple estate. Die with money in 56 bank accounts in 9 countries, like the estate I had, that took a little more work. And so in that case, there is a guideline for executor compensation, which is 2% to 5% of the value of the estate, depending on the complexity of the estate. Now, one of the things that people often overlook when it comes to executor compensation is that, first of all, it typically requires the approval of the beneficiaries at the same time, or at least their ability to object to it and go to court and have it interpreted. And then secondly, it's employment income. So it gets taxed as employment income. Deductions and remittances need to be made as an employment income. So I had a client recently who was looking at executor compensation, and they were one of 3 beneficiaries. And if they were taking $10,000 and they're going to get taxed at 50%, they're going to net $5,000. And if they don't take executor compensation, they're going to get $3,333 just as a beneficiary out of that $10,000. And they kind of looked at it and said, so that means I'm going to get an extra $1,700. I said, yep. And said, and it's going to add to my employment income. I said, yep. And they said, forget it. I don't want compensation. But it can be a challenging topic, Allison, can't it?
It is a challenging topic. I actually once had a lady, she was acting as her mom's attorney under the power of attorney. Mom had dementia. And unfortunately, mom didn't have any compensation clauses in the power of attorney, so she didn't receive any compensation as attorney. Then mom passed away. She was acting as executor, and she had 4 brothers. At the end of the estate, she asked her brothers for compensation, and the one brother threatened to actually physically harm her if she decided to take compensation. Obviously, huge issue. And she, at the end of the day, decided to not take compensation. But if there was something in the will with respect to compensation, then there wouldn't have been the dispute. But the will, mom, when she had the will drafted, did not want to deal with compensation because she thought that the kids would all agree.
Oh, they all get along so well. And an estate is going to make them get along better.
Yes. And so just going back, there is another question just about interest rates on an unpaid credit card. So when someone passes away, usually one of the things I will do on behalf of the executor of the estate is to contact the credit card company and ask them to waive the interest on the credit card because the assets are frozen until such time as the executor has access to the assets and has dealt with the tax liability. Most credit card companies will waive the interest.
But not all.
Not all. Most.
And to be fair, folks, I mean, the example we gave with paying a credit card before CRA, I mean, it's all relative to the scale of the estate, the scale of the debt, etc. Right?
Right.
If this is mom has a $500 credit card balance, and you've had an accountant do her tax returns for the last 20 years with her pension, et cetera, is there a huge risk of CRA? Probably not.
Right.
But if this is, you're the executor for this friend who you lost touch with 10 years ago, and they were always a little on the edge of what they were doing business-wise, and, never had a job, but always seemed to be making money, that's when you probably want to be a little more careful.
Yes. And I've recently, in the last 3 years, I've had 2 estates where the person who died, they were non-filers. They hadn't filed tax returns in 10 or more years. So in that case, I'm really happy that the personal representative did not pay any of the estate debts, because we've actually, on the one, had to retain tax counsel to do with a voluntary disclosure matter because of the non-filing, and just working through that, which we don't know penalties and interest, and it's a long process, unfortunately.
All
Okay.
right. And I think that answers also the question about executors' compensation that was there. So I think I have a bad habit here. Every time I go to share a screen, Allison, I hover over the leave button. So if I disappear, that's
Leave our presentation.
well,
I don't know how you feel about me.
I have to do the green button, not the red button. It's almost like it's color coded for me.
Matt, will you come back if Mike drops out?
Of course, yeah, absolutely.
Perfect.
Someone's got to take the mantle for sure.
All right. I think, did you do the last one? I think you asked the last category.
I'm going to pick.
Oh, I think it's my turn. Hey,
Oh,
isn't it?
it is your turn.
All right. I want to do wacky wills for 800. Let's check these out.
Okay. Wacky
Oh.
will for 200.
800. 200, 800.
800. Yeah, it's 800.
And it's not working.
Okay.
Okay, let's.
So wacky wills for 800, Mike. Answer is worst $200 I've ever spent. It wasn't on wine, I know that.
I'm gonna say, what is a fill in the blank online will kit?
You are correct for
Well, that's
$800.
fantastic. I'm gonna try and figure out our PowerPoint while we're talking about it.
Where's the deal?
I think I have too many things opened up.
Okay.
The problem.
So Mike and I, we've had this discussion before. We've been encountering a lot of wills where someone has done a fill in the blank will, because you can go buy them at the corporate registry. I don't even know if they're $200, or you can buy them online. Usually people don't complete them correctly. And what I would tell you is, if you're not paying for it on the front end, your estate is paying a lot more on the back end, because we are having to deal with these difficult wills where they may not have been signed correctly. Sometimes I have one right now that only has one witness and is in some litigation, which is unfortunate. I have another one where a lady decided she wasn't even going to buy the online wills kit. She just decided to write her own will, Mike, and get this. Then she decided to write over the will and do her own codicil to the will on the same page. And it had scrap paper. She used the backside of the paper as scrap paper to make her notes.
Wait.
It's not easy. And in terms of having to try and get that through and deal with maybe potential beneficiary disputes, it ends up costing the estate a lot more money than actually going to have a will properly prepared by a wills and estates lawyer. It's kind of like doing your own surgery. Surgery goes wrong, and then you go see the surgeon.
Yeah, it's. I had a very sad one once where a person downloaded an online will, printed it, then they filled in the blanks, they signed it, and then unfortunately they took their life. And the problem is it was the worst combination of a formal will, which is printed, typed or computer printed, and a handwritten or holographic will, which is all in the deceased handwriting. And I made a court application to have the court consider the handwritten portions sufficient to be a holographic will. And I've told this story to you before, Allison. If I was the judge, I wouldn't have granted my application because I don't think there was enough there. But the judge looked at the circumstances and decided that it was sufficient. Right. Which was very kind of them. And not that judges aren't kind, but a little bit unusual as well. I guess it's just the penny wise, pound foolish. I mean, save a few dollars, like you said, at the front end, but the legal cost of trying to rectify a will, or the risk of it being challenged because it's invalid, it just doesn't make sense, even for a pretty basic, straightforward estate. It can end up costing tens and hundreds of thousands of dollars, depending on the size of the estate and depending on just how litigious the beneficiaries are.
Right. So yes, we strongly recommend going to see a wills and estates lawyer to have your will prepared, not just the lawyer who maybe did your real estate deal, because the knowledge, we are specialists in what we do. I'm not saying you have to come see one of us, but really, with anything you do, with anything legal, I do recommend that you do go see a specialist rather than to go see a generalist, because I would rather go see someone who actually specializes than a jack of all trades and a master of none. But that's my own personal preference. And just seeing some of the wills that have been potentially drafted by generalists, they miss some of the big issues that we see in the litigation side. Unfortunately, I think the litigation side has given us a lot more knowledge as to what needs to go into the wills to prevent litigation after someone passes away.
All right, I am going to try this.
Okay.
Can I just jump in real quick, just to touch
guy?
on that fast? I know that you mentioned you don't necessarily have to come and see the two of you. I would recommend one of the two of you for sure. But there are also several other estate practitioners that the foundation can connect you with. So if there are anytime you want to get more information about the folks who present these sessions, we're happy to provide that. So just providing that resource to anybody who might be listening.
That's really appreciated, Matt. And yeah, I mean, Allison, you're right. It's just good to deal with somebody who doesn't just sort of dabble and do the odd will or the odd estate. Same way I wouldn't dabble with someone who does the odd tax return or the odd, I don't know, knee surgery. Well, I'm an eye doctor, but
knee replacement surgery on you?
Exactly. I'm going to try and do this again. Let's see if it works.
One of our colleagues, I'll just keep talking while you're trying to do this. One of our colleagues who practices in the area, she says every time she sees a holograph will, she gets a new pair of shoes.
Yes.
She doesn't say that when she does someone's will, only when she sees the holograph will. So that just tells you the difference in the cost.
Okay, so where are we on? What are we on now?
I'm going to take probate problems for $1,000 since you're beating me.
Oh, I wish
Oh, I just went through this. What is naming beneficiaries that cannot be found?
Look at that. It's as if it's word for word, Allison.
Shocking.
Incredible. You ever had a file like that?
Yes.
What did you do?
Aside
from hire Magnum.
I know. I wish Magnum, and it's not Tom Selleck anymore. There's a new Magnum.
I know. It's not the same.
So unfortunately, one of my favorite clients, she died when she was 106. We redid her will when she was 102. And in her will, because she was 102, most of her immediate family members had predeceased her. So she was going down to great nieces and great nephews. In her will, we had 72 beneficiaries, Mike.
Oh my.
But she was 102. I wasn't going to say no.
72 beneficiaries.
Yes.
I'm sure you had current mailing addresses and locations for each and every one of them?
I actually did. I did not have to play Magnum.
Wow.
GIR. But I also had an estate where the deceased lived quite an interesting life, never spent a lot of time in one location. And he prepared his will and had about 20 beneficiaries, named his sister as the executor of his estate. She was unable to find his address book or anything on his computer, and we were unable to locate 5.
Holy smokes. That's yeah, you know, I'm dealing with one right now where the deceased had a level of disability, had done a will many years ago, had not a huge estate, but also made small, like we're talking $2,000 specific bequests to 5 people. There's no one to administer the estate. Someone volunteered to step up and be the executor. Nobody knows any of these people. We've hired a private investigator. They've tried to track down these people. Now, it sounds kind of funny. These investigators now use a lot of internet and social media, but all these people are either old or likely deceased and probably predate most things on the internet. And so he was able to find 1 of the 5 were confirmed to be deceased. And we've spent more than $10,000 trying to find people for $10,000 totals of gifts. So
Yes.
it's disappointing, but there's literally nothing else we can do. And we are now at the stage where we have to go through a process to say, we can't find these people. Here's the report, and make an application to have them declared as missing persons so that the money can get paid either into court or to the public trustee. And then the money, the rest of the estate goes to charity, and the charity gets deprived of this money because we can't find these people. So
Right.
it's
Frustrating.
it's very unsatisfying. It's not, you know, nobody wants to see money wasted, and this
No.
is a situation of money wasted.
So similar story. I had an estate. The deceased had 4 children. He was estranged from one of the children, so he didn't name her in his will. When I was talking to the executor, I was like, well, this child wasn't named in the will. Is she, by reason of disability, unable to earn a livelihood? And the answer was yes. I was like, uh-oh, we need to serve her. So I ended up hiring a private detective to try and locate this woman. The private detective called me and he's like, you can locate her between this street and this street by this church. This is where you can find her wandering. So he gave my business card to someone at the church. The lady started calling me, but the issue was she started calling me at 2 a.m.
Oh,
when I wasn't in the office. I don't work your
you
hours,
weren't?
Mike.
Come
I
on.
know. So it became a situation. We didn't know if she was homeless. We were unable to locate her. But because I was unable to serve her, we couldn't actually proceed with the application for the grant of probate. It became a very unfortunate situation. And then my client actually received a call from the police and she passed away. So I was like, we didn't need to serve her, but it became a very sad situation because they had been estranged from her for years and didn't get to
Right,
see her.
and so if a beneficiary can't be found, then you go through this process of having them declared as a missing person, and the funds end up getting held for them unless you can prove that they are deceased. It is very challenging. Now, there are ways within wills to draft around that, to put a clause in a gift that says if a person cannot be located within
2 years or something.
then then for the purposes of the will, they're deemed to have been deceased, and the gift fails. But I'll be honest, that's rare. I mean, when we're doing planning for people, generally they know who they're gifting to and they know where to find them. And we've asked for that information. So it's not very common to put that clause in unless you are dealing with different circumstances.
It's also the situation too where people maybe life changes and they don't update their wills. And so again, with your wills, I know this is a state administration, but it really all starts on the planning side, is to take a look at your will every 3 to 5 years or after any significant events. And if it still meets your needs, no reason to update. But if it doesn't, maybe it's time for a little update.
Absolutely.
Okay. We back to
Okay,
Jeopardy.
so let's see if it'll work again. Okay, I think it's my turn now. I'm gonna go probate problems for 200, Allison.
Good. I like that you're picking the low numbers because I
You
think I'm still
betcha.
winning. Okay. We're going back to the game, Mike.
Yeah, all right. Oh, sorry. There we go.
Okay. The deceased told me the original will was taped to the door, but I can't find it.
What happens when you can't find the original will? Okay, pretty close. I think.
So I will give you the $200, Mike.
Thank you, Trebek. I appreciate it.
Maybe Matt needs to weigh in. Maybe he.
No. He's harder on me than that. So
No, I think just the reference to Trebek earns you the
there you go.
Consequences of not locating the original will. This seems to be popping up more in my life and I don't like it.
Yeah, it's I mean, there's layers of this, right? There's not locating the original will, but you have a copy or an original scan of it, or etc. And then there's a process where, as lawyers, we can apply to the court to say this is a, the executor swears this is a true copy of the will, etc., or we made a true scan at the time of making the will.
Yes.
Then the next layer is, I know they had a will. Here's the draft that was never signed. Can we probate this? You ever done that, Allison?
I have. I recently had that where, you'll like this story, Mike.
Okay.
So I recently had a client, or clients, they were acting as the personal representatives of the estate. They were the children of the deceased, and they had a true copy of a signed will. So it just had the quotation marks where she signed it and the date. It was found in her belongings with an original enduring power of attorney, original personal directive, the invoice from the law firm where she had paid for the documents. And I contacted the law firm to see if they had the original will. They said they were not able to find it. The personal representatives were receiving, the 3 kids of the deceased were receiving 75% of the estate. And then the remaining 25% was going to the grandchildren. So it doesn't follow the rules of intestacy, because if she died without a will, everything would go to the 3 kids. I had the kids as beneficiaries of the estate sign a consent that they believed that this was the last will of their mom, and that they believed that the 25% was to be divided amongst the beneficiaries when I did my application for a grant of probate. And the judge bounced me and said it's presumed that she destroyed the will.
Yeah, it's
And I was like, so yeah. And then
Yeah,
I went back to the law firm and asked if they could look to see if they had any records of what the usual practice was of the lawyer that retired. and I didn't get anywhere. So then I had to reapply for a grant of administration. Unfortunately, that meant that the grandkids lost their gift from grandma.
Yeah, and you know, it's and law firms have different practices. And you know, that is something that is not consistent, and there's not a right or wrong answer.
No.
Generally speaking, there's two approaches. One is and it's more typical in smaller firms. They don't keep the original documents. They give them all back to the people who made them. Say, you've got the originals, you take care of them.
Yes.
And I mean, I guess the lawyer's secret to that is, if you're a sole or small firm or a solo practitioner and you want to retire and you've got a whole bunch of original wills, you've got a problem. And then there's firms that are bigger or have been around a little longer, like yours and mine, Allison. And I think you guys keep originals at your shop as well. And so we put originals in a fire vault. We do, you know, scans of them, have them electronically saved to the cloud, etc. And
Where's your cloud, Mike? I was asked that question.
in Canada.
Just asking.
It's
Ours
in
is
Canada. And it's not really a cloud, it's a big server farm, but and so that's a service we provide, and for our firm it works well. We've been around since 1895, so we're not going anywhere. And when I retire in 40 or 50 years, I'll be able to know that there's going to be people that take over those files. But
Yes.
But it can be a real challenge. And there is no central registry for wills where you deposit the original wills, nor, in my opinion, should there be, because I wouldn't trust a private company to do it. And by the same token, I wouldn't trust the government to do it. So
if the will is with the person when they died, or the original will is with them and is unable to be located, the presumption is that they have deemed to destroyed it and that there is no will. There is some cases that go back and forth where, depending on the circumstances, you can prove that they may have had a will or something happened. But again, makes it difficult, and it makes it more costly for the estate on the back end. My preference is that we store the original will. But if the client insists on keeping it, then they keep it. But at least if our office were to be set on fire or a flood or something destroyed, I can swear an affidavit that we had the original will.
right, exactly. Might be a good time just to check off a couple of the questions. I'm not sure we can get into some of them that are super specific. You know, one of them.
Yeah, sorry, I'll just interrupt you, Mike. Sorry. If you
Yeah.
do have questions after this, I think Matt can provide you with our contact information and we can try and answer your questions. We know we're on a short timeline, and Matt usually keeps us within our timeline, so we'll try and stick to the presentation. But again, if we don't get to it, please feel free to reach out to us.
Yep.
Happy to answer questions.
And I might just throw a few quick answers to these that are up there. There's one about the best time to talk about personal representative compensation. Generally speaking, there's no best time. There's only a worse times. But it's good to have that conversation at the outset. Typically, though, it happens towards the end of an estate when we're getting to the distribution stage. And part of the reason for that is you don't know how complicated an estate's going to be until you work your way through it. Question about life leases. I think that's a little too specific for today. So I'm not sure we can really deal with that.
Life leases are complicated.
Yes. Naming adult married children who as co-executors. As long as they don't get along and fight all the time, then definitely name them all as co-exec. No, I'm joking. It's a challenge. If you name more than one person as executor, they all have to work together. So naming 3 adult children as executors of an estate, they all have to work together. One of them's in a different province. The surrogate digital service that exists here requires that at least one of the executors be a resident of Alberta. So that's a consideration when it comes to that. The Jeopardy Q&A in a PDF. I'm sure that somebody will know how to get that to you. It's not me or Allison, but we will work with Matt to make that available.
As long as we can get the slides or however it's set out, then absolutely we can follow.
Adil has the slides. She's
yes, absolutely
knows exactly what she's doing. She's
I have them. I just don't know what I'm doing.
We can get those out to everybody who's registered. Yes.
And Allison, beneficiary won't respond to executors.
A beneficiary, they would only need to, they won't respond. It really depends what they're not responding to. Because if you're trying to, maybe they're not, if they're not responding with respect to an interim distribution or an accounting, then there might be a requirement of the executor to pass accounts before the courts, which just means they have to show their records to the court, money in, money out, and proposed compensation. If they're refusing to do that. I have, where beneficiaries are refusing to receive funds, I unfortunately had a will where whoever drafted the will for the deceased decided to give a gift of $1 to a son she disliked, which is kind of a slap in the face. I wasn't a fan of it, but I had to notify him that he was a beneficiary, and then I had to send him a check for $1.
Yeah, and if someone doesn't want their inheritance, they can disclaim their inheritance to an estate, and I do that sometimes more than once seems like a surprise to me, and I've had to do it several times.
Is there a definition of an estranged person beneficiary? If I'm excluding, if I have instructions from the client to exclude someone from a will, so for example, if they decide to give their estate to 2 children and not all 3 children, I will actually put a note in the will that they, after careful thought and consideration, have decided not to include them. And that's purely for the purpose that, first of all, I don't get sued after the fact that there was my error for not including them. And also just in case the person tries to contest the estate for some reason, to say that it was my error and they were supposed to receive half of the residue, that it's clear that they were not.
Yeah, and I'll do that, or I'll offer to either do that or not do that, so that they're not named at all, and just memo my file explicitly in that respect.
Yeah.
All right, I think we better get back to our.
Okay. I saw Ron's note about loans. That is a great note, but we can get to that after.
Okay, perfect.
That's probably battle of beneficiaries.
Let's see if it's gonna. Allison, I think you are up.
Okay. Can I pick disinherited and devastated for $400?
Well, yeah, you sure can. I was left by my parents.
That's not very nice. Good thing I drafted their will and that's not
What do you think
true.
the answer to that one is?
What is testamentary freedom in Alberta?
Yes, we talked about that earlier on. Look at that, he even got a chime. You want to talk a little bit about that and disinheriting people?
Yes. So again, as Mike had said at the beginning, we do have what's called testamentary freedom in Alberta. We basically have the 3 rules. So you should not receive less on death than you would receive on divorce or relationship breakdown. 2, you need to provide for your minor children. And 3, you need to provide for adult children who are unable to earn a livelihood. And then there's that period of time when they're in university too, 18 to 22.
Yeah.
So otherwise you can do whatever you want. You don't necessarily need to leave it to family members. If you have decided you do not want to leave it to them, subject to the 3 rules, you can leave it to charities. You can set up a trust for your dog in your will if that's what you want to do. Those are always fun to draft. I'm a big fan of my dogs. They have their own trust in my will.
You know what else you can do, Allison? You can
What?
set up a fund at the Edmonton Community Foundation.
That is also an excellent idea.
Absolutely. And that way you get the charitable giving along with a whole set of professionals behind them to help you and your estate deal with all of that charitable giving and making sure it benefits those charities or those causes that you feel strongly about.
And I know with our new budget out the other day, there's some, I think, favorable rules for donations to charities.
Yeah, there some favorable news for sure, based on some of the proposals that were going around earlier. But to Mike's point, we would love to have that conversation with you here at ECF to talk about anything around charity or supporting the community. So don't hesitate to reach out to talk to us about that.
Yeah,
And-
and that's why we do this. I mean, the ECF does such great work and gives Allison and I the opportunity to do these presentations. It really is like the best of all worlds when it comes to charitable giving. So we're obviously big fans of doing it through the ECF.
Yes, and the ECF, one of the things about the ECF is they know about the organizations that we do not know about. So they know of these smaller charities that we don't always think about, because I know we always think of the big ones like the Stollery, the Food Bank, great organization, the Humane Society. But if there's other organizations you might be interested in, or you want to donate to the arts or whatever your passions are, then they can help assist you with setting up an endowment fund.
Absolutely.
Yeah, and that goes for charities, not just simply in Edmonton, working on some funds right now that are moving dollars across the country. So it doesn't just have to be here local. Any of your philanthropic wishes, we should be able to accommodate.
Fantastic. All right. I think it's
Okay, Mike, what are you taking?
I'm going disinherited and devastated for, I'm gonna one up you. I'm gonna go 600.
Just trying to beat me. My common law partner isn't divorced and his wife is getting the estate in his will.
Oh, Allison, what is too complicated?
This is complicated, Mike.
Boy, oh boy. Have you ever had one of these files?
I do. I had to go into the rules. So because they are not divorced and still married, the will stands.
Wow.
But the common law partner can make a family maintenance and support claim to receive all or part of the estate because she wasn't included.
So basically what this is a great big complicated mess.
Yes, it is a complicated mess. This is a situation where a person's life changed significantly and they did not update their will to reflect their new life.
Yeah, it's a lot of people don't like to talk about these things because if you don't talk about it, it'll never happen. And unfortunately, it's going to happen to everyone. And as such, it's so important to talk about. And especially when you get traditional family is not a very common thing anymore. Blended family is much more common, and it poses all sorts of other challenges.
So just so you know, in Alberta, what a common law or what we call adult interdependent partner is, or sometimes Mike and I will shorten the term to AIP. Yes. I think it's funny because adult interdependent partner is a mouthful. So in Alberta, to become an AIP, you need to live together for 3 years or have a child of the relationship. And upon relationship breakdown, we have the Family Property Act, and Mike and I are not family law lawyers, so please don't ask us those questions. An adult interdependent partner can make a claim similar to that of a married spouse.
Yeah, so you can have similar to that of a married spouse, along with a married spouse, and then you throw some children into the mix, and it's a complicated and expensive estate all of a sudden.
And I'm sure everyone gets along, right?
Oh, yeah. I wouldn't
First
a
wife, like
still married spouse and a
girlfriend.
common law almost supposed to be, best friends. Well,
Sure.
but they can be aligned at who they're all mad at, and that's the person who's gone. So,
Right.
yeah.
So
Should we
fail
do a
your task.
couple more here?
Sure.
Okay. Let's see here. You did.
I will take intestate intrigue for 800.
Okay. Estate to my niece instead of my stepkid.
What are the unintended consequences of not having a will?
Look at that. Word for word. You are really good at this.
Yes. We had talked about this a little bit earlier, so yes.
Yeah.
In Alberta, you do have testamentary freedom, but if you don't do a will, our government has decided with their legislation where your estate goes. So first would be to a spouse, if it's a first marriage.
And what if or what if that spouse predeceases though?
Then it would go to kids.
And what if those kids aren't your kids, but are your spouse's kids?
Then not to those kids, unless you legally adopted them.
And which happens rarely when it's stepkids, right?
That's true. So then it goes up to your parents.
Who have predeceased.
Then it would go to your siblings.
Who have predeceased.
Then it goes up to your grandparents.
Who of course have predeceased.
Then it goes to aunts and uncles on both sides.
All of whom have predeceased.
Then it goes to your first cousins.
Don't have any.
You don't have any first cousins?
Well, I do, but my file doesn't.
I think that's where it stops in the parentalic
Niece.
distribution chart.
You missed the niece.
I missed the niece.
It goes to the parents, siblings.
Oh yes, the parents, siblings, children. Yes,
And
and
then
then
siblings,
to the
children.
first cousin.
Yeah, and I'm dealing with one right now, and it's a situation where actually the person hasn't passed away, but no longer has capacity and will die intestate. And it's a very strange circumstance where we're trying to prevent the intestacy having unintended consequences, but we have to prevent it without being able to make a will. So stay tuned. I'll let you know how it works out, Allison, but it's just, and it was another one of these circumstances where they just didn't want to talk about it. Didn't want to talk about doing a will, didn't want to talk about losing capacity. And that's where you run into these circumstances. And, I specialize in cliche law, and this is the ounce of prevention versus the pound of cure.
I just tell people, you sign your wills, you sign your estate planning documents, you throw them in the drawer and you don't think about them. You don't want to wake up at 2 o'clock in the morning and be like, I need to do this. I'm off on vacation tomorrow. I'm leaving my kids behind. What's going to happen?
Absolutely.
You just do it, and then you don't have to think about, I promise you, highly unlikely anything's going to happen right after you sign it.
Let's see, what else? Allison, I'm gonna one-up you again. I'm going to intestate intrigue for 1,000.
Mike, I think you might be winning if you get this answer right.
I hope so.
All 8 children are personal representatives of the estate. Good times.
I'm gonna say who has full rights of administration. I still did the form of a question. I said who, not what. Does
Okay.
that count?
Alex can weigh in.
Trebek, I think Trebek says okay.
I think maybe he ditched us.
No, I'm still here. Sorry, I was typing out something in the
Ah.
chat. But yes, I'll give it to Mike, even though I heard
Okay.
the music kind of drowned him out. But I trust him.
Oh,
Okay.
perfect. That was my plan, to have the music drown me out, so it's working perfectly. So no will.
Yeah, there would have to be no, or there may be a will, but the executors are dead.
Right. Then but especially with no will, who has that first right to be the we could, in this case, you call it an administrator instead of executor.
Yeah. Sorry, administrator. Personal representative covers both.
Yes. So all the children would have equal priority, but Allison, do you know there's a little secret extra priority?
What is the secret extra priority?
There's a secret extra priority for children who are residents of Alberta.
Oh, what if they all live in Alberta?
Then there's no secret extra priority.
No,
But I've used that before. I've used the Alberta one before, where Alberta has a right to apply before outside Alberta.
okay.
So it's, I mean, so what you can get into, folks, is just a battle on who is best suited, who wants to take it on. If it's like people in my family, it's a battle of, no, you do it. No, you do it. I don't want to do it. You do it. But you get into those battles, right, Allison?
You get into those battles, and the other issue with having all 8, if there were 8, is that all need to be unanimous in all decisions related to the estate.
Good luck.
Which makes the estate move very slowly and can potentially be very costly from a legal fees perspective. Even just to pick who is to be the real estate agent to sell the house, all 8 need to agree, all 8 need to sign off on, all 8 need to sign off on any offers.
Wow.
And to
Yeah,
get
no.
everyone gathered together.
It's it can be a real challenge, and then the court has to decide who has priority to apply, if anyone, if not anyone, all of them. And it can just be a complete mess. Do all 8 of them get to claim executors fees, Allison?
Probably. But if they're probably the only beneficiary, hopefully they're the only beneficiaries if it's an intestacy.
Right.
It may not be an intestacy, well, because if there was another child that predeceased, it could go to those grandchildren
So,
potentially.
but they take it out of one pocket and put in the other one, is what you're saying?
Yeah.
Yeah.
And
I think we're getting towards the end of the game.
they're not paying tax on it.
We're pretty close to the end of our Jeopardy game. Why don't we power through those real
Okay,
quick?
have 7 minutes.
Yeah, is that okay, Matt? And we'll
Yeah, for sure. I was just going to come on and say you could do a few more answers if you wanted to, and
Okay.
then we could take maybe a couple of questions in the Q&A before we wrap up.
Sounds good. Beneficiary battles, Allison. You got one there?
I'm going to take beneficiary battles for 1,000.
Oh, you took the top one. I knew it. Okay. Oh, I'm having a challenge again. Okay, this one's not working. I'm just gonna have to read it to you.
Okay.
Title is in the name of a corporation.
Oh, this one makes me cringe. So, what is gifting something owned by a corporation and not the person in their will?
I'll make the dinging noise. Ding. That is correct. What is
So-
gifting something owned by a corporation and not the deceased? I know you've had this before, Allison.
I know you've had this before. So part of our job when we prepare wills for people is people tell me they own things. They tell me they own land. I end up pulling titles, their land titles specifically, to see how they specifically own something. And sometimes people just mix up their corporation and themselves. They consider it one entity, which in their life, it is one entity. Unfortunately, from a legal perspective, a corporation is a separate person from the individual. So if a person is trying to gift property that is in the corporation, they don't actually own it. So if I were to give my friend Mike my house located on 100th Street and 100th Street, but it was actually owned by corporation ABC 123, I can't give it to him in my will. I can say, as of the date of this, my will, I own all of the shares in this corporation, and it is my intention that my personal representative takes such steps to transfer the property to my friend Mike. But you can't actually give it.
Yeah.
So it becomes a huge error and leads to, unfortunately, lots of litigation.
Yeah, that's very much the truth, because as a shareholder, all you own is shares. You don't own what the corporation owns. Like, and so, yeah, dealing with it, it's problematic. It's problematic for the estate, the beneficiaries, the lawyer that prepared the will potentially. Sometimes clients are, challenge us and say, you don't need this information, just do the will the way I say it is. And your lawyer has to be confident enough to say, no, I need all the information. If I don't have the full picture, I can't achieve what you want me to achieve. And I know, Allison, you do this too. Sometimes when meeting with clients, I don't ask them what they want to do. I ask them what they want the end result to be. And then we figure out how to get there, because sometimes what they think they want to do won't achieve the end result they want.
And there's also tax consequences and all those things that we need to talk about because of the deemed disposition on death. Okay, Mike, we have 3 minutes. Can we ask one more question?
We can try if I don't know if this is working. Let's see.
Oh, here we go. Oh, there we go. Okay, Mike has picked beneficiary battles for 600, and it's, but I want mom's jewelry and she told me I could have it.
That's right. And I'm going to say, what is the failure to address personal property in a will? And then I'll quickly stop sharing since I can't make the PowerPoint work properly.
This never happens, right?
Oh no, mom told me all sorts of things. She wanted me to have this, she wanted me to have that, and but she didn't put it in the will, and that jewelry's probably not worth very much, right, Allison?
Not worth anything at all. And I see my name. There's a piece of Scotch tape with my name on it, so I'm sure I can have it, right?
Yeah, it's a constant challenge in estate planning that people like to say, I've taken care of these things, you don't need to put them in the will. And it's often, it's not even things that are that valuable. It's things that have sentimental value that cause problems.
I am currently, this is not my file, I am currently aware of a 6-year dispute over a, get this, Mike, a grapefruit spoon.
That could sour somebody. Gotta go with the dad joke when I can.
Oh, that was a bad joke.
Matt, I know we've run up against.
I think that was a great pun to end on there. So,
do you think we have time to do a few questions?
Yeah, I think so. I know that Allison mentioned one about loans that you were going to come back to, but there are still a few questions in the Q&A that if you wanted to roll through 1 or 2 or 3,
sure.
However many, go right ahead.
Okay, so loans is a big issue. It can be a very contentious issue. It can be something that can be a huge beneficiary battle. When you give your children money, our courts have said when you give them money, it's deemed to be a loan unless the child can prove otherwise. If you have given your children loans to purchase their first home, my brother Jimmy, my parents gave him money to purchase a business, you need to address that in the will. So when I updated Ron and Marilyn's will, my parents, I was like, hey, how do you want to deal with Jimmy's loan? Poor Jimmy. And they're like, oh no, that's just, he needs to repay the loan. And if he doesn't, it's his share should be reduced by the loan amount. Some people, they're trying to gift to their children equally, and then they just say all loans are to be forgiven on death and not to be taken into account. The personal representative of the estate has a duty to maximize the estate, so their goal is to collect those loans unless the will states otherwise.
I'm gonna pick off that last question there, Matt. It talks about a 71-year-old child of the deceased who suffered a stroke a year before they became a beneficiary from mom's will, and that person also earns a pension, and if they're considered a person under a disability. The short answer is yes. If they're unable to earn a livelihood due to a mental or physical disability, then they have a right to advance a claim. That doesn't mean their claim's successful, and taken into account is the scope of what's inside the estate, things that go outside the estate, like life insurance designated, or RSPs or RIFs designated, and takes into account the assets of the person under the disability and the needs of anyone else advancing a similar claim. But I will just quickly share a story that I had a file where a sister had swooped in and got mom to change her will to disinherit the brother, and it likely would have been effective. There probably wasn't enough evidence to say that there was undue influence. I won't say fortuitously, because nobody wants to have a stroke, but the adult son had a stroke, was unable to earn a livelihood, mom died, and he had the ability to advance a claim and actually get part of the estate because of his disability. So it was a roundabout way of defeating the disinheritance. So that's a very nuanced question, and a lawyer's favorite, one of our favorite phrases, that it's very fact specific. Will depend on the facts of each circumstance.
Heard that a lot this week during the presentations. A lot of it depends, and it certainly depends on the circumstances. So maybe before we just wrap up, just because it's in here, I might get shut down automatically here. My computer needs maintenance, so maybe we might not be able to get to it. Bad timing here. So maybe I'll wrap up before I get shut off here. But thank you very much for your presentation today. Really appreciate the time that you both put into this, and always appreciate the humor that you bring to these presentations. So thank you very much for being here. Thank you to everybody for tuning in today. It's great to see so many people jump on a Friday afternoon and spend some time with us. As I mentioned, the recording for this should be available next week. And it sounds like we are going to have the slides to be able to share as well. So again, before I run out of time here, thank you to everybody for being a part of another great estate administration week. If there are any materials or resources that ECF can provide to you, please let us know. We'd be happy to do that. And in the meantime, have a wonderful weekend. And I thank you both again for being here and being a part of this. So thanks, everybody. Take care. I'm going to stop the recording now. Have a great weekend.
Thanks, Matt.